going over some key things to consider in divorce and separation agreements. So let's start with the educational issues. People might not know that both parents do not need to sign the IEP for it to become effective. Only one parent needs to sign it, and then the school goes. So this can be a big issue when the parents are disagreeing about what, for example, the placement the child should be, what school they should be going to, and that kind of thing. So I kind of agree with the law because you don't want the child to be in limbo while the parents are arguing, and you don't want the school involved in that. But on the other hand, when you're negotiating your separation agreement, you should be thinking about this kind of thing of who's going to be in charge of the education, what's going to happen if you disagree. So generally, we like to recommend that you set up a parent coordinator for this kind of problem that you automatically go to, and the parent coordinator helps you work it out. Otherwise, you're going to end up back in court, and your child might be missing out. Another issue that you need to think about is where is it, when you think about custody, is where is the child going to live could affect the program they're in. So there used to be a rule, they called it the pillow rule, of how many nights a week the child put their head on that pillow. That's the district that pays. But recently we had the Ames decision, Ames versus Wayland School District, where the parents won, and they said, no, it can't just be the pillow rule. It has to be other factors about where the child belongs. And the court agreed. And the court said we look at things such as their domestic, social, and civil life. Where are they? Where have they been? Where are their friends? Where is their community? So that's a very good decision for us, but it wasn't a very high court, and it's not really, I can't say it's the law of the land. So I want people to be aware that when they think about custody, they should consider what it could do to their funding of their school district. And check your town's rules, because the rules vary. And then we also see a lot of problems with the medical, therapeutic, extracurricular activities, disputes where, for example, one parent thinks that the child needs to be on meds and the other doesn't. And, what sometimes happens is the one that doesn't think they should be on meds doesn't give them the meds when they're with them, and then they go back to being on the meds when they're home, the other home or whatever. So these are big issues that, we have to do what's right for the kid. And, again, I recommend a parent coordinator for this kind of thing to make sure that everybody's on the same page. Let's see if I have more on this. Before I get to Veda versus Veda, the other thing I want to mention is the transition problem, because, transitions can be hard for a lot of kids, but they're particularly hard for our special needs kids sometimes, and that should be thought through. How are you going to do it, and can you create some routines to make it easier for the child that both parents maybe follow? You want to minimize the difficulty of transitioning to the point you can. And I was just listening to Judge Smoot, a retired judge in Suffolk Court, who was talking about how he handles these problems. And he mentioned that he has parents, he says to them, you'd do anything for your kid, wouldn't you? And the parent says, yeah. You'd die for your kid, wouldn't you? And the parent says, yeah. And you can't be civil to your ex-spouse for the 4 minutes average it takes to transition between the two? You can't be kind and say nothing at those 4 minutes for the benefit of your child? And I bring this up because there's a lot of research that shows that conflict is what really sticks with the child and can hurt the child as an adult. So you want to try to minimize that conflict, and transitions is one of the times you can do that. Okay, so the rest of my talk is going to be about child support and financial issues, financial government benefits that can help the custodial parent support this handicapped adult child, as they could be living with the parent for many years. And child support in Massachusetts is statutory. And I'm going to talk about this case, Veda versus Veda, to explain to you exactly how child support works for what they call an emancipated person. So Veda versus Veda is a recent case, I think it was last year, came down, where what happened is the father, they were getting divorced, or they weren't yet divorced. The father took their 2 boys to the Cape, and he was playing with them, and he put them on the car bumper and ended up running over both children. So one of them, is a quadriplegic for life. The other one was severely hurt but is better, got better. So the one that is a quadriplegic, the mother sued the ex for child support, and she wanted child support to last past the age of 23, which is what our statute says, that you can get child support for any child through age 23 if they're still in college. So it ends at 18. If they go through a higher education, it can end when they turn 23. So what the court held is no, the custodial mother is not entitled to child support after the child turned 23 because this child who was in a wheelchair was competent and did not need guardianship. So the child actually went to BC and graduated from BC. So he still was smart, he just didn't have the physical ability. So the law in Massachusetts, and it's not totally logical, but if you have guardianship, somebody has guardianship over your child, which means they don't have competency to make their own decisions, then as a matter of equity, the court can require child support for years after the child turns 23. If the child is not under guardianship, it's done. Under statute, you cannot get child support after that unless you can get the ex to pay voluntarily. So those are the general rules, and I want to talk about what other resources are available to this custodial parent if, let's say, their child support is ended. I think of the case where maybe the mother had a career, gave it up to take care of this special needs child, or certainly worked less and had a lot on her plate, and now she's keeping the child as an adult. How can we help pay for the cost of living for that child? So the first thing I want everybody to understand is that when your child turns 18, they are considered an adult. I don't care what their actual state is. The law considers them emancipated. So that means when you are getting divorced, you need to think about who's going to be the guardian of this child. If they need guardianship, who's going to be the guardian? Because you have to go to court and apply for guardianship if that's what they need. If they are competent enough to make their own decisions, maybe with some support, you can do less things like a power of attorney and health care proxy. We do not recommend going and getting a guardianship over someone who can make their own decisions safely. But if they can't, at age 18, one or both of the parents needs to go to court to get guardianship over the child. The other big thing about 18 is that your money is no longer that child's money. And that's nice because all of a sudden your child qualifies for needs-based government benefits that they could use. So even though they're still living at home and you're still taking care of them and all, they're poor. And so you want to make sure that your child, if they are in this position where they might be able to qualify for these needs-based government benefits, which I'll talk about, don't want to be giving your child money in their own name. They can have no more than $2,000 in their own name to qualify for these. So once they turn 18, my child, as soon as he turned 18, he qualified. So child support, and I'll get into this, but child support is considered the child's money. So even though you write the check maybe to the custodial parent, Social Security, Mass Health, they consider that the child's money, and Social Security will decrease your SSI payment dollar for dollar by that child support that came in after the first $20 that they don't count. So we'll get into discussing that. But so I want to go through these benefits, and then I'm going to talk about child support and how we can make sure that the child support doesn't impact on the benefits. So here's a list of the major government benefits that could help the custodial parent take care of the child, housing and caregiving after they become an adult, after they turn 18. Now I start with DDS here because if you can get housing from DDS, your financial problems are pretty much solved. The DDS will pay for their housing, their food, their day program and all that, and you just are there to help with around the edges. But as I understand it, only 15% of DDS qualified people get housing. So, and in order to be the DDS qualified person, you have to have an IQ of around 70 or less and have some functional limitations, unless you're autistic or you have Prader-Willi or Smith-Magenis, two kind of obscure chromosomal disorders. Those three diagnoses, you do not have to have your IQ less than 70. That requirement's been eliminated. As long as you have the functioning problems that they're looking for, you could still get DDS qualification. But the point I'm trying to make here is that most of us, even though we're qualified DDS people, are not going to get housing paid for. So that's why I want to go through these other programs. So let's start with SSI. I don't know how to see if I can. Oh, here we go. This is the big one, money. It's money in your pocket. It's supplemental security income. You can start getting it when the child turns 18, and if they're living at home, which is really the scenario we're talking about with the custodial parent keeping the child with them, it's going to get about, in 2015 dollars, about $576 a month. So it's need-based. That means the child can't have more than $2,000 in order to obtain it. And if you happen to have a child like this that has more than $2,000, you should spend that money before you apply. Don't transfer to someone else, but spend it if you can, or you can put it into a trust. We could talk about that. But so this is the main reason we want to worry about child support. We want to not interfering, because it'll decrease this amount by however much you pay. How do you become eligible for SSI? Well, you have to prove you're disabled, and they usually just they ask you for every record known to man. They want all your IEPs, all your psych evals, and all that kind of thing, everything you've got. Hopefully you can get them all and you have them from your school or wherever you have them in your files, because it's difficult when you have to start recreating things. They don't need to look at your child, meet your child. I brought my son in as Exhibit A, and they didn't think, they said, no, the person that makes the decision is up in like Springfield or something. We don't need to see your child, so they don't need to go. So, and I say it's best to apply at 18 when the child doesn't have a work record. And they're going to look and see, can they be substantially employed? If not, they should be entitled to SSI. And as I mentioned, they can have no more than $2,000 in assets in order to receive the money. And there are some offsets once you are in the system and receiving SSI. Assuming you're living at home, you don't have to worry about this in-kind income, because they've already taken out 1/3 of your payment, assuming you live at home. So the upper limit is $260 of reducing it if you're living at home. And if you're in DDS housing, DDS gets 75% of your SSI after the child turns 22. If the child works, they kind of want you to work, so they don't reduce it dollar for dollar, they reduce it by 50%. After, first there's an initial $20 disregard, and then there's another $65 a month they don't count. If you work a little bit, they won't count it. And then after that, they reduce it by 50%. So if your child receives SSI, they automatically receive Mass Health. And that's a really nice feature. You don't have to apply. The card comes in the mail without you doing a thing. And that Mass Health can be vital for this kind of situation, because not only does it provide the medical insurance, but it also can provide some of these, it pays for day have if you need that and that kind of thing, and it also can provide some caregiving money to help that custodial parent. So if you don't happen to go through the SSI route and you need to apply for Mass Health separately, then there's no asset limitation. You can have more than $2,000, but you still have to have a low income. Or you can get Mass Health Common Health, and it's the same exact coverage, except you have to pay a premium and a deductible. Okay, now I want everybody to understand that Social Security Disability Income, SSDI, is very different than SSI. And I'm sorry that has such a similar name, but SSDI is like a disability insurance policy that you've purchased by paying into Social Security. When you, as a parent, turn 65, if you have a disabled kid, your child will automatically be entitled to 50% of whatever your payment is, whatever you paid in. When you die, your child gets 75%. So that's a wonderful thing, and you don't have to worry about that $2,000 asset limit. You don't need to have a money in a trust or anything like that, because you can be a millionaire. You still get SSDI because it's based on the money you put into the system. A wonderful thing about SSDI is it comes after 2 years of being on SSDI, your child on SSDI, they get Medicare automatically. So Medicare is not needs-based, and it provides some things that Mass Health don't. So it's nice to have both coverages if you can, and they're called dual eligibles. So this adult foster care, also known as adult family care, or AFC, is one of the main programs that people use when their adult or over 16 handicapped child is living at home and they need help with the caregiving. So the big problem with this for divorced people is that the caregiver cannot be the legal guardian. So it's hard because when you're divorced, you both want to be co-guardians, generally speaking. A guardian means something. It means you get to make all the decisions on the important things like the medical, educational, where they live, whether they should have an operation, all that kind of thing. So if you can think of somebody else to be the guardian, the caregiver, such as if you have an adult sibling living at home, they could be the caregiver, but the person has to live with you, and you can still be the co-guardian. But we do know situations, not infrequent, where a divorced family has to forego this benefit because they both need to be co-guardians. AFC provides 2 levels of care depending on how much assistance your child needs with the activities of daily living. So level 1 is you only need a little bit of help here, and level 2 you need more. And so the provider comes to your house and interviews you and meets your child and figures out which level you are, if any. And then your payment is based on your level. So level 1, you get about $9,000 a year, and level 2, $18,000 a year, tax-free, paid to you to take care of your child. So this is a great benefit if you have Mass Health. Another Mass Health program that's excellent is the PCA program, Personal Care Attendants. You can't have both AFC and PCA, so you get one or the other. They both are for caregiving. The PCA, you pay the PCA for the hours worked. So, again, the provider comes and interviews you and assesses how many hours you need a week, and then they pay that PCA, and it can be you, if you're not the guardian, right now $13.68 an hour. Another thing that everyone should be aware of for special needs kids is Section 8 voucher, because that portable voucher is really a wonderful thing, and the kids should apply as soon as they turn 18. It takes 10 to 12 years right now to get the voucher, apparently, on average. Some people get it quicker, but once you get it, it's a really great thing because it's portable. You can use it in this state. You can use it anywhere in the country. It's a federal program. Move to California, you still have your voucher. What the voucher does for you is that your child will pay 1/3 of their income to the landlord, and HUD will pay the rest. So if they're only making SSI or SSDI, they'll pay 1/3 of that to the landlord. 2/3 of it goes to is paid for by HUD. Okay, so we're going to go through the impact of child support on these programs, and then we'll talk about what we can do about that. So if you're receiving, let's say, $500 a month in child support, your SSI payment will be reduced dollar for dollar. After that first $20, it'll be reduced to $480. So it's basically, you know, SSI would have been paying you, now it's your ex paying you. You get the same amount of money. That's not really very helpful. So if you have a situation where you think you're going to be entitled to child support or receive child support, and again, it's a matter of equity with the courts, you don't know. The court thinks it'd be fair for you to receive child support after for years. It's worth putting your child support into a self-settled special needs trust, which I'll talk about. Then none of this will be deducted, and you'll get the full SSI plus the full child support. Mass Health and Section 8 can also be affected by child support because they look at your the child's income per month, and child support will be considered their income. So Mass Health, you might have to pay more in premium, and for Section 8, they're going to take that into account in determining what's your 1/3 payment when you pay your rent. So what's a special needs trust? A special needs trust is a regular trust where you put the legal owner of an asset is the trustee for the benefit of someone else, but it's different because it has to be completely discretionary how the distributions are made by the trustee. The trustee has the sole, absolute, and unfettered discretion on when to pay out the money. If that's the case, then the money will not be counted as your child's money by SSI. So it's important that the trusts are written properly. The beneficiary, your child, cannot demand distributions. They can't have the authority to revoke it or terminate it. They can't direct the use of the money in any way. They can't sell it. And again, it has to be completely discretionary with the trustee how the money gets paid. So the special kind of trust, normally when you do your estate plan, if you have a special needs, I'm just filling this in here. If you have a special needs child, you're going to want to have a special needs trust created for that child, unfunded, that is ready when you pass, their share goes into that trust, and then it won't be counted, and it'll be taken care of for your special needs child by someone else who can manage their money and do the right thing. So that's a different thing than I'm talking about for child support. For child support, because the money is considered the child's own money, you need to do what we call a D4A special needs trust. And D4A is called that because that's the name of the statute of the Social Security Administration that allowed these trusts to be created. And so you put them, you create them, and you fund them immediately with the child support or whatever else the child has in money to make sure it's not counted by SSI. And it has to have certain specific features for Social Security to allow it. You can't do it for somebody that's over 65, so you have to be under 65. It has to be irrevocable. It can't be created by the beneficiary. It has to be created by the parent, grandparent, guardian, or court. So generally when we do estate plans for special needs parents, we go ahead and create a D4A trust at that same time just so it's ready, because sometimes we find our people need to have one and their parents are gone. And it's really a pain to go to the court to get one created. Grandparents are long gone. There's no guardian. So we go ahead and create them early. Also, it has to have a payback provision. So in other words, any money left in the D4A trust, when your child passes, goes to Mass Health to pay them back for whatever they paid. I wanted to mention the ABLE Act because this is another way. I'll get back into the D4A and how to work that, but if the ABLE Act, you may know, federally, it passed a year ago. And what it allows is we can save for our handicapped children the same way we've been saving all these years for our regular children, typical children, to go to college. So they're called 529A accounts, which is, it seems only fair because, you know, here we are saving for our typical children, and the ones that really need it, we're saving nothing because they have to be poor. They have to have less than $2,000. Well, once the ABLE Act becomes operational, which we hope in the next 6 months or so in Massachusetts, we'll be able to open these accounts. you'll be able to put this money into an ABLE Act account that will not be countable by SSI, up to $100,000. Now, there's some limitations. You can only put in a maximum of $14,000 a year, and it can't be used for anything at all, although more than higher education, which was $529. It's broader than that. You can use it for other things, but it's not something where you could just use it for anything you want to. I don't really recommend it for child support because it's going to be awkward. Can you imagine using a 529A plan to pay your monthly fees of your typical child? It's going to be like that. You're not going to get the distributions coming in and out. Won't be as easy as it needs to be for child support to pay your monthly bills. But it's an option. It will, I hope, be an option to consider. So for child support, we recommend that you, as part of your divorce decree, if you haven't already finalized your divorce, or in a divorce modification, if you have to bring a modification to do this, you get a court order directing that the child support be paid to a D4A special needs trust. And here's some language we use for our decrees. So if, sometimes you get divorced and you really don't want to go back to court and get a modification, it'll open up a can of worms or whatever. If the child has capacity and is able to sign their own documents, they can irrevocably assign the child support out of court, and it will be honored. But if the child is under guardianship, lacking capacity, you need the conservator, not the guardian. The guardian's for the person, the conservator's for the money, to make that happen. So sometimes I'm telling people in this situation, get the conservatorship at the same time as you get guardianship because it's cheaper and easier that way to do them both at the same time. But when you get the conservatorship, it has to actually state that the conservator has the power to irrevocably assign child support to a special needs trust as part of the decree for conservatorship. If it doesn't state that, once again, you have to go back to court as a conservator to get that special power by separate order. Here's the conservatorship language. Another idea to get around this is to call it alimony. So Social Security does not consider alimony to be the child's own money and will not decrease your SSI payments. This can be a problem, though, because it changes, the recipient has to pay taxes, and so sometimes it's not worth it to do that, taxes on the alimony. And then another thing is people try calling it unallocated family support, and that doesn't exactly work. What Social Security does is just divides by the number of people. So if there's 2 children and a spouse, they'll divide it by 3 and say that share is your child's share, and we're decreasing SSI by that amount. Now, if the non-custodial parent is voluntarily agreeing to pay this child support, things are much easier. Then there's no problem with it being considered the child's money. You don't need a legal order. They can set up a third-party trust and put that money in there, and there's no payback required in that trust when the child dies to Mass Health. Now, we recommend, when somebody comes in, they have a 4-year-old autistic daughter, we don't recommend that we worry about a D4A trust, funding money, setting that up and all that at that point, because things change so much by the time they're older, and it's awkward to have to put child support into a trust. So we recommend you come back, be aware of these issues, but don't do it till they get closer to 18 when they're actually going to have money that they need to have in that trust. Okay, so that's the end of my formal presentation, and I'm ready to take some questions. Does anybody have any questions?
Oh, hi. Thank you, Karen.
Yeah.
I have a question.
Yeah.
Does supported decision-making count as guardianship? You said that if they have a guardian, they don't have a guardian, they don't have to pay child support after the age. And I was just wondering if supported decision-making is counted as a type of guardianship?
It isn't. Assuming it's not like a limited guardianship, assuming you didn't go to court and get some type of guardianship, it doesn't count.
Okay.
So that's the thing, you know. I mean, guardianship is kind of a weird, I understand it to some degree why you would make that as the key factor as to whether you can go to the court for more child support as a matter of equity. But on the other hand, some people think that that is not the way we should be determining whether more child support is required. So, but it's statutory in Massachusetts. There's no judge that can change that. It would be the legislature would have to change it. So the statute says if you're under guardianship, you can seek equity. If you're not, you can't. And guardianship means the formal guardianship when you go to court and get the decree.
Okay. So Paula Davis chatted in a question. What percentage
yeah. Go ahead, Carrie.
Okay, what percentage of child support is considered hers? If I have 3 kids, is it 1 out of 3?
That's a great question, and yes, it's divided evenly.
Okay. How about anybody else have a question? I guess I have another question. I mean, if you're considering a divorce, it just seems like this is really important information for you to know before you go and make any formal proceedings. When do you recommend that individuals contact an attorney to kind of learn more about this? When they're kind of thinking that this may not be continuing for them, or, do you have any thoughts about that?
Well, I normally see people when they're looking for their estate plan. Okay. And that's when we get into all this. So when you're thinking about a divorce, you might also be thinking about other things. And if you have other reasons to be talking to us, that would be a good time to sort of pick our brains. Otherwise, you can just call me or people like me. But I think people on the line now, everybody's trying to educate themselves so that if they ever need this information, they can have it in the back of their mind. Oh, I need to think about that. Oh, I need to think about this. It's all issue spotting, right? And I've been talking to a lot of divorce bars lately and making sure they are all aware of all these issues so they can bring them up. The divorce lawyers know, so that'll help.
Yeah, great idea. Good. Okay, we have another question. My daughter is 16. I just applied for PCA hours. Should I have asked for AFC instead, as it pays more?
All right, that's interesting. If your daughter is getting 18 hours or more of PCA services, you're better off with PCA. That's about the cutoff. So what I would recommend is for that person to use an agency that does both PCA and AFC services, and they can work out together which one would be better.
Okay, good.
Carrie, I see another question there. Do you see that?
Okay,
above?
Yep. Okay. What might be a relative baseline cost of setting up a trust, guardianship, et cetera, understanding how each individual case has its own complexities?
Well, for the whole thing, we charge around $4,500. But if you're just wanting to come in for a special needs trust, a self-settled one for your child support, it'd be less than that. But I'm going to read the other one. What is the likelihood of getting 100% guardianship if the ex is wanting 50% guardianship? Yes. So if the ex has been involved and has joint custody and all that, they're likely to get co-guardianship. So you have to show that it wouldn't work. If you can show the judge that you are not able to make decisions together, it's going to screw up that, because when you're co-guardian, you have to make decisions, both of you have to agree, or you end up going back to court, unless you have like a parent coordinator or some kind of mechanism set up. So the person that wants 100%, they need to show the judge why that other person shouldn't have be a co-guardian. The court's reluctant to do that, but you can do it. And what I would do is make sure in my offer in the guardianship decree to tell the ex about, I'll give them access to all medical records, access to all doctors, teachers, all that thing. You'll keep them informed. Put it right there in the guardianship decree so that you give them what they need without actually being a co-guardian, and the judge is more likely to go along with that.
Okay. let's see, there was a comment that says non-custodial X. Not really sure what that question is, but here's another one. When a parent retires and starts collecting Social Security, do you have to apply for the disabled child's piece? What if you elect to defer collecting Social Security at retirement age? Does the disabled child need to wait too?
All right. So in this state, it seems automatic. I've seen people get it automatically. You don't have to go back and apply. It automatically starts coming as SSDI, and it's going to be more usually. But if you retire, and obviously you have to be 66 or whatever the age is, right? If you retire and you start collecting SS and your child doesn't start getting it, go to your agency and explain it and make sure it starts happening. But you normally don't have to reapply. So if you want to defer, what they do is what I recommend is you file and suspend. And that means you file, but you don't take your money yet because you want to get the more money when you wait till you're, 69 or 70. And you file until your kid can start getting that 50% immediately. Now, when you turn 69 and you start collecting your full amount, your child will not be entitled to 50% of that full amount. They're still going to only be entitled to the amount that you got when you were 66. So don't wait and to get your benefits from your child thinking you're going to get more benefits later. And then so that's if you defer. Does the disabled child need to wait too? Okay, I think I answered all that. If I didn't, let me know.
Okay, how about any other questions? Does the child get this from both parents?
Well, either one. There's going to be a maximum. You're not going to get it doubled. Whoever retires first, I'm not exactly sure how that works, but if both parents are paid into the system, they're entitled to it from either one or the other, but they're not going to get double.
Okay. And what things can be paid for from the OBRA 93?
Okay, so OBRA 93 means that self-settled D4A trust I was talking about. The thing is that can only be to the benefit of your child. So anything basically can be paid for anything as long as it's the benefit of your child. If you pay it for food and housing and food and shelter, it decreases your SSI unless you've already taken that 1/3 because they may be living with you or whatever. But if they're living alone and they're getting the higher amount and then you do pay food or shelter, something towards food or shelter, it will decrease the amount. But other than that, it can be used for anything for that child. Again, it's a sole beneficiary trust, and that's important because, remember, Mass Health wants the money when the child dies, so they don't want you using it on anybody else but that child.
Okay, great. Any other questions we have from the attendees? Wait a couple minutes to see if somebody wants to chat something in. There was a question in the very beginning about sharing in networking, sharing emails and networking. If you would, what I'm going to do is email you all Karen's PowerPoint through a PDF after this session's over, and you're going to see everybody else's email addresses. If anybody doesn't want me to share their email address, just let me know. Just chat in now, and I won't put your email address so that you guys can connect if you're interested. So we do have another question. If I have car payments, can I pay from OBRA because I need the car for her?
No, that's not sole benefit.
Okay.
You can push it. Sometimes people do things like that, and it's okay. But I wouldn't recommend it if you can find another way of doing it.
Okay. Can I allocate it?
Yes, that would work. My general advice is to try to not do anything too creative because Social Security doesn't like it, and then you get audited. So just try, if you can, pay for things that are directly for her or him. That's better.
Okay. If she lives with me, can I pay utilities?
so we're assuming that they're already, you understand that that reduces SSI by paying that because that's housing, but assuming that that's not a problem, can you do that? Can you use the money to pay that? Well, I guess you can allocate and use it that way, her share.
Okay, my son is 17 and a half years old. Think I should start ASAP working out guardianship strategy, et cetera, ASAP? How long does it take to get in front of the courts?
Yeah, you should start now. It takes a good 3 months, maybe more. I mean, it's all is not lost if you don't have guardianship right when he turns 18, but I always say start when they turn 17. So yeah, start now. And the main thing, the guardianship strategy, I don't know, but the main thing you need to do is if it's assuming they're intellectually handicapped, you need to get that clinical team report signed, and that takes a month, because you have 3 different signatures you need to get. You need to get a medical doctor, a licensed sociologist, and a licensed psychologist. So, or licensed social worker, pardon me. So I find that's kind of the hardest part. Get that thing signed up. Then you're ready to file your petition. So I would get going, yes.
Yep.
And then, of course, it depends on the court, but I'd say 3 months generally even once we start with the petition, because then you have to serve it, then you have to wait and see if there's any objection, then you get your hearing date, so it's a process.
I was going to also offer, too, that the ARCs, a lot of us have information on where to go to get the social work evaluation, because that is usually the most difficult one to find. So just contact your local ARC or, the ARC of Massachusetts. We'd be happy to help you with that. So let's see. Okay, we got another question. If a child gets low-income housing, buy or rent, can a parent live with them?
That's an interesting question. I believe so. I'm not sure about that. I think so. I mean, you can use Section 8 for your own house if you have a separate entrance, a separate unit in your own house. You can use that Section 8 voucher and charge your own child rent. You can use Section 8 for a group home. So, but I'm not exactly sure about that question.
Yeah, probably be best to, ask your local housing authority.
Right.
Whether or not that can be. In my experience, I haven't seen that happen. But you never know.
Well, because when they start talking about your income, they want your income to be counted too then. Yeah. But if the parent isn't working, that's probably the problem.
Yeah. So another question, does the school report count for all 3?
So
I think you're referring to the clinical.
I think it's very handy to have the school, if your child's still in school in a place that has a social worker and a psychologist, to have them sign it is the best way to go. But you still have to go to your medical doctor, right? So that's the third that you still have to go and get after you've got your school on board.
Yep. Okay, anything else?
So people should feel free to email me if they have questions or give me a call.
So now your email isn't on the I'm looking at the last page. Can you tell people your email too, Karen?
Oh, sorry, it's not on here. KBM, as in Karen Burroughs Mariscal, KBM@margolis.com.
Okay, great. And, okay, there is another question. It is okay for an over 93 account to grow in value over $2,000?
Yes, the whole point of it is that none of that money is counted as your child's money. So it can have $2 million in it, and it doesn't get counted.
Okay. Any other questions? Wait a couple minutes. All right, then. I think we're all set. Karen, I really appreciate you doing this. It was a wealth of information. I learned a ton. And I want to thank you all for attending today. And it's if you have interested in attending further webinars, they're listed on our website, which is you'll be directly routed to after this webinar. So, again, thank you all for attending, and I hope you join us again. All right, bye-bye.
Thanks, Carrie. Take care. Bye-bye.